I thought I was buying a quiet ranch in Texas, but one survey stake uncovered a secret that 60 families hoped I would never find. The first thing I wanted after closing on my new property was silence. After 15 years of running commercial construction projects across 3 states, I had grown tired of constant traffic, endless meetings, and cities that never seemed to sleep. My name is Grant Walker, and I bought the ranch because I wanted room to breathe. The property stretched across thousands of rolling acres filled with old oak trees, grazing pastures, seasonal creeks, and enough open space that sunrise felt like it belonged only to me. The previous owner had retired to Florida, and aside from replacing a few aging fences, the ranch seemed ready for a peaceful new chapter. My plan was simple: build a new horse barn near the northern pasture, restore several miles of fencing, and enjoy the kind of mornings where the loudest sound came from cattle instead of car horns. Before construction could begin, I hired a licensed survey company to confirm every property line. It was nothing unusual. Every contractor I had ever trusted always said the same thing: measure first, build second. That decision changed everything. The survey crew arrived early on a cool Tuesday morning with GPS equipment, historical plats, and enough technology to pinpoint boundaries within inches. I spent the morning checking water lines while they worked across the ranch. Around lunchtime, my phone rang. It was the lead surveyor. His voice sounded strangely calm, almost too careful. "Grant, I think you should come up here. There's something you need to see." Surveyors do not usually sound nervous, so I climbed into my truck and drove nearly 2 miles toward the northern ridge where they had gathered around one of their monitors. When I stepped out, nobody spoke immediately. They simply looked at the screen. The surveyor finally pointed toward a cluster of rooftops visible beyond a row of mature trees. "Do those houses belong to your ranch?" he asked. I laughed. "No, that's the HOA subdivision next door." He slowly turned the monitor toward me. Bright red property lines stretched across the digital map. Then he zoomed in. The neighborhood was not next door. According to every deed, every county record, every satellite coordinate they had verified that morning, the subdivision sat well inside my ranch boundary. I stared at the screen, convinced something had to be wrong. The surveyor opened another layer showing historical plats recorded decades earlier, then another showing tax parcels, then another showing the original legal description attached to my deed. Every version matched. I counted rooftops one by one. 60 homes. An entire HOA neighborhood standing on land I had legally purchased only 3 weeks earlier. Nobody spoke for several seconds. Finally, I asked the question that seemed impossible. "Are you telling me those houses are actually on my property?" The surveyor nodded slowly. "I'm saying every document we've checked today says exactly that." I felt my stomach tighten, not because I was angry, but because nothing about it made sense. Those families had driveways, sidewalks, landscaping, mailboxes, streetlights, and a grand entrance with decorative stone signs welcoming residents into Hollow Creek Estates. Somebody had approved all of that. Somebody had built it. Somebody had sold those homes. How could an entire neighborhood exist on private ranch land without anyone noticing? I asked whether there could have been a mapping error. The surveyor shook his head. "We've already checked 3 independent sources. If there's a mistake, it isn't today's survey." I walked toward the fence separating my pasture from the subdivision. Children rode bicycles along the sidewalk while neighbors chatted beside freshly trimmed lawns. Everything looked completely ordinary. They had no idea I had just learned something that could change every one of their lives. I wasn't thinking about lawsuits or headlines. I wasn't interested in forcing anyone from their home. I simply wanted the truth. Somewhere between the county courthouse and that polished neighborhood entrance, something had gone terribly wrong. As I turned back toward the survey crew, my eyes stopped on the elegant brick monument at the subdivision entrance. Mounted beneath the neighborhood name was a polished bronze plaque that read, "Managed with pride by Hollow Creek Homeowners Association." I took one last look at the monitor, and a single thought echoed through my mind. The HOA had absolutely no idea what I had just discovered. For the next 2 days, I barely slept because every answer seemed to create 3 new questions. I called the survey company again and asked them to repeat every measurement from the beginning. They brought in a second crew with different equipment, different software, and another licensed surveyor who had never seen the property before. 6 hours later, the results matched down to the inch. The northern subdivision was still sitting inside the legal boundary described in my deed. I expected someone to tell me there had been a technical mistake, but nobody did. Instead, they quietly suggested that I speak with a real estate attorney before taking another step. That was exactly what I planned to do, but first I wanted to understand the people living there. Early Saturday morning, I drove toward the subdivision entrance. The brick monument looked even more impressive in daylight. Fresh flowers lined the landscaping, colorful banners hung from decorative light poles, and every lawn looked carefully maintained. Families walked their dogs, children rode bicycles along wide sidewalks, and neighbors waved as they passed one another. Nothing about the neighborhood suggested conflict. It looked like the kind of place anyone would be proud to call home. That was exactly why I knew I needed to proceed carefully. The homeowners were probably just as unaware as I had been. If mistakes had been made decades earlier, they were not the ones who made them. As I stood near the entrance studying the layout, I noticed a sign announcing the monthly Homeowners Association meeting later that afternoon inside the clubhouse. I hesitated for several minutes before deciding to attend. Walking into that building without introducing myself first felt dishonest. I believed the board deserved an opportunity to hear what I had discovered before lawyers became involved. At 3 o'clock, I entered a spacious clubhouse decorated with framed community awards and photographs of neighborhood events stretching back years. Around 40 residents had already taken their seats. Conversations filled the room until a woman wearing a bright designer jacket, oversized jewelry, and expensive sunglasses stepped confidently onto the small stage at the front. Even indoors, she left the sunglasses resting on top of her carefully styled hair. "Good afternoon, everyone," she announced with practiced confidence. "I am Patricia Holloway, your Homeowners Association president." The room immediately became quiet. Patricia carried herself like someone who expected agreement before she even spoke. After discussing landscaping contracts and budget updates, she asked whether anyone had new business to present. I slowly stood. Every face turned toward me. "My name is Grant Walker," I said. "I recently purchased the ranch bordering the north side of this neighborhood." Patricia smiled politely. "Welcome to the community. What can we help you with?" I held up a folder containing copies of the survey maps. "I recently completed a professional boundary survey, and I believe there may be an issue involving the property lines between my ranch and this subdivision. I wanted to share the information before making any assumptions." Several residents leaned forward with curious expressions. Patricia accepted one of the maps and glanced at it for only a few seconds before laughing. Not a nervous laugh, a dismissive one. She looked back at me and smiled as though I had just told a harmless joke. "Mr. Walker," she said loudly enough for everyone to hear, "our neighborhood has been here for over 20 years. We have county utilities, paved roads, property taxes, and recorded deeds. I assure you, nobody accidentally built 60 homes on someone else's ranch." A few people chuckled. I remained calm. I understand how unusual it sounds. That is why I wanted to discuss it respectfully before anyone overreacted. Patricia handed the survey back without looking at it again. "Professional surveys are not always correct. We trust the documents we already have." I nodded. "Would your board be willing to compare your records with mine?" She folded her arms. "There is nothing to compare." The confidence in her voice surprised me more than the words themselves. She had not asked who completed the survey. She had not asked whether county records had been reviewed. She had not asked to see additional documentation. She had already decided I was wrong. One board member quietly whispered something toward Patricia, but she simply waved him off. Then she looked directly at the audience. "Ladies and gentlemen, sometimes new neighbors misunderstand old property boundaries. Fortunately, that is why homeowners associations exist. We protect our community." More laughter followed. I did not argue. Instead, I calmly placed another copy of the survey on the board's table. "Please keep this. If you ever decide to review your records, my attorney and I will gladly cooperate." Patricia smiled with unmistakable confidence. "That will not be necessary." I thanked everyone for their time and walked toward the exit. Just before reaching the door, Patricia called after me. "Mr. Walker." I turned around. She smiled again, even wider than before. "You might want to save your legal fees. This neighborhood is not going anywhere." I returned her smile. "I appreciate the advice." Then I stepped outside carrying one important realization with me. Patricia had not challenged my evidence. She had simply refused to look at it. And sometimes that was the most expensive mistake a person could make. 3 days after the Homeowners Association meeting, I received a certified envelope from a law firm downtown. I already knew it was coming before I opened it. Patricia Holloway had looked far too confident to simply ignore what I had shown her. The letter confirmed exactly what I expected. The Homeowners Association had filed a lawsuit asking the court to declare that the neighborhood had acquired permanent rights to occupy the land because it had existed there for decades without objection. They argued that removing any uncertainty was necessary to protect homeowners who had purchased their properties in good faith. I read every page twice before placing the documents on my kitchen table. Strangely, I did not feel angry. I felt curious. Patricia had made one enormous assumption. She believed the lawsuit would pressure me into backing away before anyone examined the history behind the subdivision. Instead, the lawsuit guaranteed that every historical record connected to the ranch would become part of the legal discovery process. I called my attorney the same afternoon. His name was Daniel Mercer, a quiet man who had spent more than 30 years handling complex property disputes across Texas. After listening carefully to everything that had happened, he remained silent for several moments before asking a simple question. "Grant, have you ordered the complete title history yet?" I admitted that I had only reviewed the documents provided during closing. Daniel laughed softly. "Those are only the beginning. If we are going to understand how 60 homes ended up on your land, we need every deed, every easement, every subdivision filing, every survey, every county record, and every transfer going back as far as possible." The following morning, we visited the county clerk's office together. Shelf after shelf contained decades of property records, many of them carefully preserved in digital archives while older documents remained stored in large bound volumes. A records specialist helped us identify every filing connected to my ranch and the neighboring subdivision. What began as a routine search quickly turned into stacks of maps, legal descriptions, engineering drawings, tax records, and handwritten notes from developments completed many years earlier. Daniel refused to rush. He believed property disputes were rarely solved by dramatic discoveries. They were solved by patience. For hours we compared legal descriptions line by line. Every time one document referenced another, we requested that file as well. By late afternoon, our conference table had disappeared beneath folders and oversized survey maps. One detail immediately caught Daniel's attention. The legal description attached to my ranch had remained remarkably consistent through multiple owners. The boundaries described decades ago matched the boundaries shown on the modern survey almost perfectly. The ranch itself had barely changed. That consistency mattered because it suggested the survey crews had not created a modern error. The property lines had existed for generations. Meanwhile, the subdivision record seemed unusually complicated. Several revisions had been filed during construction, and certain references pointed towards separate documents that were not included in the initial development package. Daniel circled those references with a red pen, but offered no conclusions. "We never assume," he reminded me. "We verify." Over the next week, we interviewed surveyors, title professionals, and former county employees who remembered portions of the original development. Most remembered the neighborhood being built quickly during a period of rapid growth. Few remembered the exact legal details. Everyone seemed surprised when they learned why we were asking questions. Despite the growing stack of evidence, Daniel repeatedly warned me not to celebrate. "The truth has a way of hiding inside small details," he said. "One overlooked document can change an entire case." While we continued digging through records, another certified envelope arrived from the Homeowners Association. This one demanded that I immediately stop making what they described as false ownership claims because those statements might create unnecessary concern among residents. Daniel smiled after reading the letter. "Interesting," he said. "They are trying to control the conversation before anyone reviews the evidence." I asked whether we should respond. He shook his head. "Not yet. Let them stay focused on their assumptions. We stay focused on facts." As the sun set outside his office window, Daniel carefully unfolded one aging survey map that had not been reviewed in decades. His eyes narrowed as he followed a faded line running along the northern edge of my ranch. He did not explain what he had noticed. Instead, he looked up at me and quietly said, "Grant, I think we just found the document that everyone else overlooked." Daniel carefully spread the aging survey across the conference table and placed a modern satellite map beside it. At first glance, nothing seemed unusual. Both maps showed my ranch, the neighboring subdivision, and the surrounding county roads. Then he traced a faded pencil line with his finger until it reached the entrance road leading into Hollow Creek Estates. "Do you notice anything?" he asked. I studied the drawing for nearly a minute before shaking my head. Daniel smiled slightly and pulled another document from the growing stack beside him. It was an easement agreement recorded more than 30 years earlier. The paper was worn, but the language remained perfectly readable. It granted temporary access across the ranch while construction crews developed the subdivision. The agreement allowed equipment, delivery trucks, and workers to use a private ranch road until permanent legal access could be secured. I looked back at the survey. "Temporary?" I asked. Daniel nodded. "Temporary." He slid a second document across the table. It described the conditions required before the easement would expire. One sentence immediately caught my attention. The developer was required to establish permanent legal access before the temporary agreement ended. Daniel opened another county record. There was no extension, no amendment, no replacement easement, nothing. We spent the next several hours verifying every reference number attached to the agreement. Each search produced the same answer. The temporary access document had been properly recorded decades earlier, but no permanent access rights had ever been filed afterward. I leaned back in my chair, trying to understand what that meant. "So the subdivision has been using my road this entire time?" Daniel answered carefully. "Legally speaking, we still need the court to interpret everything together. But based on these records, it appears the only entrance into the neighborhood crosses your ranch under an agreement that should have expired years ago." Suddenly, every piece of the puzzle began fitting together. The homes were inside my property boundaries. The entrance road also crossed my ranch. Somewhere during the original development, someone had apparently assumed the remaining paperwork would eventually be completed. Whether it was forgotten, overlooked, or never submitted, nobody seemed to know. Daniel refused to speculate. "Our job is not to guess why it happened," he reminded me. "Our job is to prove what the records actually show." During the following week, our legal team requested certified copies of every document from the county clerk instead of relying on digital scans. We hired an independent title expert to review the entire chain of ownership without telling him our theory. 2 days later, his written opinion reached exactly the same conclusion. The ranch boundaries had remained consistent for decades, and the recorded access agreement appeared to have no permanent successor. Meanwhile, news of the lawsuit quietly spread through the neighborhood. Several residents began driving past the ranch entrance more slowly than usual. A few even waved politely. One afternoon, an older couple stopped near my mailbox and introduced themselves. They had lived in the subdivision for almost 20 years and seemed genuinely confused by the rumors. They asked whether I intended to force families from their homes. I answered honestly, "No. I am trying to understand how this happened before anyone makes decisions they cannot take back." They thanked me for speaking respectfully before driving away. That conversation reminded me why I had remained patient from the beginning. The homeowners were not my enemies. Most of them had simply trusted the documents they received when purchasing their homes. Unfortunately, someone else had made decisions long before they arrived. Late Friday afternoon, Daniel received the Homeowners Association's first discovery package. Patricia's attorneys had produced hundreds of pages supporting their claim that the neighborhood had existed peacefully for decades. Daniel skimmed the documents, then quietly laughed. They included everything except the one thing they desperately needed. I looked at him. "What is missing?" He placed the expired easement agreement beside the discovery documents. Proof that they ever obtained permanent legal access. So far, it does not exist. The first court hearing arrived sooner than I expected, but Daniel looked calmer than ever as we walked through the courthouse doors. He carried only a slim leather folder, while Patricia's legal team rolled in 2 large carts stacked with binders, exhibits, and oversized presentation boards. Watching them, anyone would have assumed they had already won. Patricia certainly acted that way. She greeted several people in the hallway with confident smiles, occasionally glancing toward me as though expecting me to look nervous. I simply nodded politely before following Daniel into the courtroom. Once everyone had taken their seats, the judge explained that the hearing would focus on preliminary issues and establish the framework for discovery. No final decision would be made that day, but both sides would outline the foundation of their claims. Patricia's attorney spoke first. He described Hollow Creek Estates as a peaceful neighborhood that had existed for decades without dispute. He emphasized that families had purchased homes in good faith, paid property taxes every year, and relied upon the stability of recorded deeds. According to him, reopening historical property questions would unfairly threaten innocent homeowners who had done nothing wrong. It was a polished presentation, and I understood why several people in the gallery nodded along. Daniel listened without interrupting. When our turn arrived, he walked to the podium carrying only 3 certified county documents. He did not accuse anyone of fraud. He did not question the homeowner's intentions. Instead, he began with a sentence that immediately changed the tone of the room. "Your Honor, this case is not about what people believed. It is about what the public records actually say." He placed the original ranch deed on the evidence screen, followed by the modern survey that matched it almost perfectly. Then he displayed the historical survey prepared decades earlier. Every legal boundary aligned. The judge leaned forward slightly. Daniel calmly explained that the ranch boundaries had remained consistent through multiple owners and multiple surveys. Nothing about my property's legal description had unexpectedly changed. Patricia's attorney objected, arguing that long-standing use of the neighborhood should outweigh technical boundary questions. The judge overruled the objection and instructed Daniel to continue. Next came the temporary easement agreement. Daniel highlighted the section granting construction access across the ranch while the subdivision was being built. He carefully read the expiration language into the record without raising his voice. Then he stopped. He did not immediately explain why the document mattered. Instead, he waited. The silence filled the courtroom. Finally, the judge asked the obvious question. "Counselor, was a permanent easement ever recorded?" Daniel answered honestly. "We have searched every county record available to us, and at this point we have found no recorded document replacing the temporary agreement." Patricia's attorney immediately responded that additional records might still exist. Daniel nodded. "If they do, we welcome their production during discovery." That answer caught everyone by surprise because it was impossible to argue against. We were not claiming certainty beyond the evidence. We were asking for every relevant record to be examined. The judge agreed. He ordered both parties to exchange complete historical documentation, including title files, subdivision approvals, engineering records, access agreements, and every survey connected to the development. As soon as the hearing ended, Patricia hurried past us without saying a word. Her confident smile from earlier that morning had disappeared. Outside the courtroom, several homeowners approached me cautiously. One man asked whether the judge had ruled against the neighborhood. I shook my head. No, today was only about gathering the truth. He seemed relieved by that answer. Before leaving, Daniel quietly summarized what had happened. Grant, they expected an emotional fight. Instead, the court ordered a complete search for facts. I looked back toward the courthouse entrance where Patricia's attorneys were speaking rapidly among themselves. For the first time since this entire situation began, they no longer looked like a team preparing to win. They looked like a team trying to find something they should have located years ago. Over the next month, discovery transformed the case in ways neither side could ignore. Boxes of records moved back and forth between attorneys, surveyors compared notes dating back decades, and county employees produced archived documents that had not been reviewed in years. Daniel insisted on examining every page himself, even when other members of our legal team believed they had already found enough evidence. He kept repeating the same sentence. Cases involving land are won by details, not assumptions. Meanwhile, Patricia Holloway appeared increasingly determined to defend every decision the Homeowners Association had ever made. During depositions, she spoke confidently about the neighborhood's long history, its successful management, and the belief that everything had always been handled correctly. She repeatedly explained that the subdivision had operated peacefully for decades and that nobody had ever questioned its boundaries before I purchased the ranch. Daniel listened patiently without interrupting. When it was finally his turn to ask questions, he avoided dramatic accusations. Instead, he started with simple facts. "Mrs. Holloway, before the Homeowners Association filed this lawsuit, did the board commission a new boundary survey?" She answered immediately. "No." "Did the board compare the subdivision boundaries against the neighboring ranch deed?" "No." "Did the board request certified copies of the original access agreements from the county?" She paused briefly before answering. "No." Daniel nodded politely, and continued. Before voting to authorize litigation, did the board possess any document proving that a permanent access easement had replaced the temporary construction easement? Patricia looked toward her attorney before responding. We believed one existed. Daniel remained calm. That was not my question. Did the board possess such a document? After several quiet seconds, she answered with a single word. No. Nobody in the room reacted outwardly, but I noticed several people taking notes more quickly than before. Daniel did not raise his voice or attempt to embarrass her. He simply continued building the timeline one question at a time. So the lawsuit was approved without verifying the current property boundaries, without reviewing the neighboring deed, without obtaining a new survey, and without confirming that a permanent access agreement had ever been recorded. Is that correct? Patricia shifted slightly in her chair. We relied on the information available to us. Daniel nodded. Thank you. That answers my question. The deposition ended shortly afterward, but its impact reached far beyond that conference room. A week later, additional discovery materials arrived from the original title company involved in developing the subdivision decades earlier. Most of the documents duplicated records we had already reviewed. One envelope, however, contained internal correspondence discussing unfinished legal filings during the final phase of construction. None of the letters proved intentional misconduct. Instead, they suggested that several documents were expected to be completed after homes had already begun selling. Daniel carefully compared the dates with the county records. The missing permanent easement never appeared. Whether someone forgot, assumed another office had handled it, or simply failed to complete the process remained unclear. What mattered was that no recorded replacement had ever been found. As the evidence accumulated, attitudes within the neighborhood slowly began to change. Several homeowners contacted Daniel's office requesting copies of public filings so they could better understand the dispute for themselves. They were respectful, and many admitted they had previously accepted the Homeowners Association's explanations without question. I appreciated their willingness to seek facts instead of rumors. Throughout the entire process, Daniel reminded me that the homeowners deserved honesty because they had invested their savings believing everything had been handled correctly. Our disagreement had never been with families trying to build ordinary lives. It had always been about establishing the legal truth. A few days before the next court hearing, Daniel spread every key exhibit across his conference table one final time. Original deeds, certified surveys, title opinions, archive correspondence, and the temporary easement formed a complete timeline stretching back more than 30 years. He looked at the collection quietly before smiling for the first time since the lawsuit had begun. Grant, he said, we are no longer asking the court to solve a mystery. We are giving the court a complete history. Now we find out what the law says should happen next. The final hearing felt completely different from the first one. Months earlier, Patricia Holloway had walked into the courthouse with absolute confidence, convinced the Homeowners Association could overwhelm me with history and numbers. This time the atmosphere was noticeably quieter. The courtroom filled with homeowners, attorneys, surveyors, title experts, and county officials who had become involved during discovery. Nobody seemed interested in dramatic speeches anymore. Everyone wanted one thing: a clear legal answer. Daniel arrived carrying the same slim leather folder he had brought to the preliminary hearing. He smiled when he noticed me watching the other side unload another stack of binders. Paper only matters if it changes the facts, he quietly said. Once the hearing began, the judge summarized the months of discovery for the record. Certified surveys had been compared. Historical deeds had been verified. County archives had been searched. Independent title experts had reviewed the chain of ownership. Every opportunity had been given for additional evidence to be produced. Patricia's attorney spoke first. His argument was more restrained than before. Instead of insisting that the Homeowners Association unquestionably owned everything it claimed, he focused on fairness. He explained that innocent families had purchased homes believing every legal requirement had been satisfied and asked the court to protect those expectations. Daniel agreed with one important point before beginning his own presentation. Your Honor, the homeowners deserve fairness. Mr. Walker has said that from the beginning. The question before this court, however, is not whether these families acted in good faith. The question is whether recorded property rights disappeared simply because nobody examined them for many years. The judge nodded for him to continue. Daniel displayed a single timeline stretching across the courtroom screen. It began with the original ranch deed, continued through every recorded transfer of ownership, included the temporary construction easement, and ended with my purchase of the ranch. Every certified document appeared in chronological order. There were no missing years, no unexplained changes, no dramatic surprises, just an unbroken legal history supported by official county records. Then Daniel pointed to one empty space on the timeline. "This," he said, "is where a permanent recorded access easement should exist if one had ever been completed." He paused before continuing. "After months of discovery involving both parties, multiple title experts, county archives, and every available public record, that document has still not been found." Patricia's attorney requested permission to argue that such a document may once have existed but could have been misplaced over time. The judge responded carefully. "Courts decide cases based upon evidence presented, not documents that might have existed." The room became completely silent. The judge then reviewed several exhibits personally, asking detailed questions about the surveys, legal descriptions, and title reports. Every answer led back to the same conclusion. The ranch boundaries had remained unchanged for decades, while no permanent replacement for the temporary construction easement had ever been recorded. Finally, the judge delivered the ruling. The court recognized my ownership rights exactly as described in the recorded deeds. The temporary construction easement had expired under its own terms, and no evidence established that it had been legally replaced. At the same time, the judge acknowledged that the homeowners themselves had relied upon recorded transactions they believed to be valid and encouraged both parties to negotiate practical solutions rather than create unnecessary hardship. I felt relief more than excitement. I had never wanted anyone to lose their home. I had simply wanted the legal record to be recognized. Outside the courthouse, reporters gathered near the front steps, but Daniel suggested we leave through a quieter side entrance instead. As we reached the parking lot, he handed me a prepared legal notice. It informed the Homeowners Association that, consistent with the court's ruling, the temporary permission allowing neighborhood traffic to cross my private ranch road would end after the notice period required by law unless a new agreement was reached. Everything from this point forward, Daniel reminded me, must be handled exactly as the law requires. I nodded. 2 days later, the notice was formally delivered. There were no angry confrontations, no dramatic scenes, and no raised voices. The document simply explained the court's decision and the date on which the existing access would officially end. On the morning that deadline finally arrived, I drove to the private entrance road before sunrise. A licensed contractor hired by my ranch installed a new steel gate at the exact location identified in the surveys. Beside it stood a clearly visible sign stating that the road beyond remained private property and that future access required written authorization. As the workers completed their final inspection and quietly packed their equipment, I looked toward the neighborhood entrance in the distance. For the first time since this story began, everyone inside Hollow Creek Estates understood that the legal assumptions they had relied upon for decades had just come to an end. The days following the court's decision were quieter than I expected, but the silence did not last long. By the end of the week, Daniel began receiving calls from attorneys representing individual homeowners instead of the Homeowners Association. Their questions were remarkably similar. Nobody wanted another lawsuit. Nobody wanted years of uncertainty. They wanted to know whether there was a practical solution that allowed their families to continue living normal lives. Daniel told each caller exactly what I had told him from the beginning. I had never intended to punish homeowners for mistakes they did not make. I wanted the property records respected, the legal issues corrected, and the future placed on a solid foundation. While those conversations continued, life inside Hollow Creek Estates changed dramatically. Residents who had once accepted every statement from the Homeowners Association board now demanded answers. Special meetings filled the clubhouse several nights each week. County officials attended some of them to explain public records. Independent attorneys attended others to answer questions about easements, title insurance, and property rights. Patricia Holloway remained president, but her confidence had disappeared. Instead of giving speeches about protecting the community, she spent most meetings responding to difficult questions from the very people who had trusted her leadership. Why had the board filed a lawsuit before ordering a professional survey? Why had no one verified the access agreements? Why had the board dismissed certified county records without reviewing them? Those questions became impossible to ignore because every answer pointed back to assumptions instead of evidence. One afternoon, Daniel invited me to his office after receiving a formal request for negotiations. The letter came from the Homeowners Association's attorneys, but its tone was completely different from the aggressive filings that had started the case months earlier. They acknowledged the court's ruling and expressed interest in discussing a permanent legal resolution benefiting both parties. Daniel placed the letter on his desk and looked at me. "This is the moment where emotion becomes expensive," he said. "We negotiate based on facts, not pride." I agreed immediately. Over the next several days, Daniel and I outlined for conditions that we believed were fair. First, the Homeowners Association would purchase a permanent recorded easement across the private ranch road at a professionally appraised value. Second, the Homeowners Association would reimburse the documented legal costs directly related to establishing the property boundaries. Third, every future maintenance obligation involving the access road would become the responsibility of the Homeowners Association instead of the ranch. Finally, the agreement would require updated surveys and recorded legal documents so that no future property owner would ever face the same confusion again. We deliberately avoided demands that would create unnecessary hardship for ordinary families. Daniel explained that courts often appreciated practical solutions, and I agreed that solving the problem mattered far more than creating headlines. The first negotiation session lasted nearly 6 hours. Representatives from the Homeowners Association arrived with engineers, financial advisors, and new legal counsel. Patricia attended as well, although she spoke far less than before. The discussions were professional and detailed. Survey maps covered the conference tables while appraisers explained land values and engineers reviewed possible improvements to the entrance road. At one point, Patricia quietly admitted that she had relied on historical assumptions instead of requesting updated legal reviews before approving the lawsuit. It was the first time I had heard her acknowledge that possibility. No one celebrated the admission because everyone understood that the real goal was finding a lasting solution. As negotiations continued, several homeowners thanked me directly for choosing cooperation instead of conflict. One retired couple explained that they had spent their life savings purchasing their home and feared they would lose everything when the lawsuit began. I assured them that I had never wanted that outcome. They smiled with visible relief, and for the first time since discovering the survey, I felt that the situation might actually end in a way that respected both the law and the people affected by it. Late that evening, after the final meeting ended, Daniel gathered the revised draft agreement and placed it inside his briefcase. Nearly every major issue had been resolved. Only one final approval remained, and that decision now rested with the Homeowners Association board itself. The final Homeowners Association board meeting lasted less than 2 hours, but it brought an end to a dispute that had taken months to unravel. Every board member had received the negotiated agreement several days earlier, along with independent legal advice explaining the consequences of rejecting it. When the vote was finally called, the decision was clear. The agreement passed by a comfortable margin. No applause followed. No dramatic speeches filled the room. Instead, there was a quiet sense that everyone finally understood the difference between assumptions and verified facts. Within the following weeks, surveyors returned to the property one last time, not to search for mistakes, but to record permanent solutions. The new easement was professionally surveyed, clearly described, signed by every required party, and officially recorded with the county. Future owners of my ranch would know exactly where the access rights existed, and future homeowners inside Hollow Creek Estates would never again have to wonder whether the entrance to their neighborhood depended on forgotten paperwork from decades earlier. The Homeowners Association also accepted responsibility for maintaining the private access road under the terms of the new agreement, removing that burden from my ranch entirely. Watching the final documents being filed gave me far more satisfaction than winning the lawsuit ever could. A clear public record would protect everyone long after the headlines faded. Several weeks later, another election was held inside the neighborhood. Patricia Holloway chose not to seek another term as president. Whether she stepped aside voluntarily or simply recognized that the community wanted new leadership, I never asked. A new board promised greater transparency, regular legal reviews, and independent surveys whenever significant property questions arose. It sounded like common sense, but sometimes common sense arrives only after expensive lessons. Life on the ranch slowly returned to what I had originally imagined when I signed the closing papers. The new horse barn was finally completed. Fresh fencing stretched across the northern pasture, and quiet mornings once again became filled with little more than birdsong and the sound of cattle grazing across open fields. Occasionally, I would pass homeowners entering or leaving the neighborhood through the newly established easement. Many of them waved, and I always waved back. There had never been any reason for ordinary families and a ranch owner to become enemies. The real problem had been incomplete records, misplaced confidence, and decisions made without verifying the facts. One afternoon, the older couple who had stopped near my mailbox months earlier knocked on my front door. They brought a homemade pie and thanked me for choosing cooperation instead of trying to make the situation worse. I smiled and told them the truth. The law solved the property dispute. Respect solved everything else. They laughed, and before leaving, the husband looked across the pasture and quietly said, "I think this place finally feels like neighbors again." After they drove away, I stood near the same fence where I had first looked toward the subdivision after the survey crew called me over. Back then, I believed I had discovered a problem that could never be untangled. Looking at the neighborhood now, I realized something important. Property lines define ownership, but honesty defines how people move forward after mistakes are uncovered. If Daniel had rushed, if I had reacted emotionally, or if we had ignored the evidence in favor of assumptions, none of this would have ended the way it did. Instead, patience, careful records, and respect for the law turned an impossible situation into a lasting solution. As the sun settled over the Texas pasture, I realized the ranch had given me something more valuable than open land. It had reminded me that the strongest foundation is not concrete or steel. It is the truth, pro pearl.